Good afternoon. I want to first thank Drs. Gillespie and Amin for having me, and Ms. Spencer-Stephen for facilitating my visit. In August 2016, the Brazilian federal government mandated that all applicants for government job openings in public universities who self-declare as racial minorities appear before a local race commission or examining board. The latter is explicitly required by the new law to verify, quote, the candidate's phenotypical aspects, which will be obligatorily verified by the presence of the candidate, end of quote. Self-declaration, along with an opening to unspecified local regulation, was the Ministry of Education's policy until the August 2016 mandate. Some academic institutions, however, had implemented phenotypical verification well before then. The University of Brasilia, for instance, had done so already in 2004. This regulatory mechanism, known as racial court, Tribunal Racial, is the government's boldest effort yet to stem the rising tide of legal challenges that has beset the racial segment of the country's Sistema de Cotas, or Quotas System, which is an affirmative-action program. The latter gives preference to the disabled, the economically disadvantaged, graduates of public high schools, and specific racial groups, notably Amerindians and persons of African ancestry, in public sector jobs and university admissions. Beginning in 2012, the government mandated that 50% of university seats be made available to graduates of public high schools and Afro-Brazilians. Now, litigation and media interest heretofore have been spurred by the federal program's interstitial racial category, pardo or parda. For the government, the category preto, the straightforward black in Brazil until it was jettisoned in educated quarters for negro, and the category pardo of European and undefined amount of African and or Native American origins are subsets for the government of the category negro. Other times it is stated that persons of pardo color or preto color are eligible for the racial quotas for government posts, which are set aside for negros and pardos. Whether colors or categories, where does pardo end and branco, white, or negro, black, begin? In other words, when does afrodescendente, or Afro-descendant, literally, end and branco begin? And I'm going to use Afro-descendant, although it went out with Arthur Ashe in the 70s, because I believe that Afro in this context is a way of the Brazilian government to not stipulate that one has to just have origins from Africa in order to enter into this category of Afro-descendant. It also admits people who have mixture of Native Americans. I recall a case from the university in Rio Grande do Sul, which is the southernmost state of Brazil and has a a colonial history of great German and Swiss migration. The USFM, which is a very large university there. A case started in 2009 and ended in a federal appeals court several years later. It involved a Brazilian teenager who had secured a parda quota at the USFM, but subsequently had her university seat taken away by the race board there. A cohort of 3 blacks and 2 whites had asked her if she felt discriminated against because she was a parda. She replies that she did not. Now, the race board did not call into question her genealogy. They argued instead that having a black grandfather did not in and of itself entitle her to a parda quota. The intent of affirmative action, they argued, was to remediate discrimination, and for that intent, she was not a parda. In another mixed race case stretching from 2013 to 2015, phenotype became the expert witness and sparked a media firestorm. At the center of it was the white doctor, in bold letters, as several media outlets referred to him, medical resident Matias Abramovich from Rio de Janeiro, who applied as a racial quota to the Ministry of Foreign Relations Diplomatic Corps. In a 2014 interview, he argued, quote, "There can never be a racial court," end of quote, and that to be or not to be a pardo was irreducible to phenotype. He explained that his maternal grandparents were pardos and a paternal great-grandmother was negro. The Afro-Brazilian advocacy group EducAfro filed a complaint with the ministry, which replied that there was no provision in the 2014 law that allowed them to perform, quote, "a visual verification," end of quote, of the candidates for racial quotas. That very same year, the federal government began setting aside 20% of government posts for Afro-descendants for a provisional 10-year period, and stipulated that all candidates who self-declared as racial quotas were subject to having their nose and lips measured and their skin tone and hair texture examined by the local race board. Yet the controversies continued. Court of Appeals rules that quota candidate must look black, blared an October 2015 headline. Now, the idea of a race verification board originated with the Movimento Negro, or Black Movement in capital letters. I would like to sample a methodical and searing defense of the federal mandate posted by a blogger named Gorda e Sapatão, and that is literally fat girl and dyke. Find it down here. It is titled, the post, "Oh white person, give me a break." A branco dá tempo. Throughout, she shifts the moral and legal burden of racism from blackness, or negritude, to whiteness, or branquitude, in Brazil. Here, branquitude, or whiteness, is synonymous with white privilege. She explains that the race court was caused by afroconveniencia, or Afro-convenience, literally, a brilliant inversion of subversion of afrodescendencia, or Afro-descendants. Afro-conveniencia, or Afro-convenience, is rooted in blackness as property, if I may flip Cheryl Harris's signature essay, whiteness as property. Afro-convenience is enacted when branquitude selectively stakes its claim to negritude, which, the blogger observes, quote, "usurps our legal right to access public job openings through racial quotas," which translates to you all, once again, occupying our places with no fear whatsoever, with the total assurance of being whites and calling yourselves blacks whenever you feel like it, end of quote. Gorda e Sapatão rejects the idea that genotype or ancestry equates with phenotype. Quote, "You white women and white men feel no shame whatsoever checking that you are preto or pardo on the form, because you have in your heads the contrite colonizer's litany. But my grandfather is black. My aunt is black. As if a blackness from your ancestors were automatically transposed into you all's skin. That's not how it works, folks." End of quote. Now, the softness of the pardo category within racial affirmative action and the phenotypical verification now required by federal law together bear an unsettling resemblance to Brazil's colonial past. In the 17th and 18th century, the noun pardos included persons with varying degrees of black, African, and or Amerindian lineage. The pardo problem of today runs even deeper, in fact, streaming from the categorical and epistemological crisis triggered by racial mixture in the late 16th century, which was to produce the vertiginous arbitrament of racial probabilism. Now, probabilism in the field of moral theology, or Catholic ethics, argued that in matters of conscience, not admitting of moral certainty, Catholics could safely follow an opinion established by a reason and a single grave authority, even if that opinion was not the more or most probable of opinions. By racial probabilism, I mean a cohesive and polycentric movement within moral theology and law that debated the generational and geographical reach of civil laws and Catholic laws designed to privilege new converts to Christianity. New converts meant neophytes. In the Indies, New Worlds, or trans-ocean lands, all of these names were used interchangeably by popes and the later schoolmen to signify Spanish and Portuguese colonies outside of Europe. So they didn't use the term New World in a singular. They used New Worlds to include all of the colonies outside of Europe. Beginning in the 16th century, debates about the name neophyte, or new convert, centered on persons of African, Native Asian, or Native American descent, and especially on persons of mixed descent. That is, people who were half Spanish and half Asian, or 1/4 African and 3/4 Native American, or half Native Asian and half African. What connects racial probabilism and disputes about this name, neophyte, or the name mestizo, mixed person, because this is the term that the Pope uses. Probabilism developed in the 16th century precisely when the philosophical school known as nominalism, name giving, nomen in Latin giving the term nominal, and nominalism in English, began to sharply influence all of Catholic education. Now, nominalism, which actually dates to the medieval era, was opposed to realism. One way of simplifying this split is to ask, what's in a name? Nominalists did not believe in categories and universals. Rather, they focused on individual instances, on particulars, on cases. The fact that law, for example, today, is argued by precedent and by cases is a product of the probabilist and even going back further of the nominalists. You have to study the particulars of something. Hence the term casuistry, meaning cases, arguing by cases, which led to economic theory, statistics, modern law, and a host of other disciplines. Moral theology and its debts to nominalism are legion, for moral theology was a Christian ethics and a training for living as a Christian in society. So moral theology handbooks present scenarios, and I can give you one about races. For example, a half Indian wants to marry a 1/4 Asian. Can those two be legally, lawfully under the Catholic Church be married if the woman had already been married during her quote-unquote pagan past? Okay? There are numerous of these sort of racial story problems in moral theology handbooks. The moral theology, the adjective moral was derived from the Latin word that gave us mores, or customs, or practices. So a moral history was a social history or a cultural history. The moral theology handbooks written by racial probabilists therefore focused on the practical, on the quotidian weighing and determination of intents and actions, which were always radically particular and contingent. You couldn't make one rule about Catholic marriage that applied to all of these different racial categories. What's in a name? The answer of racial probabilists was, it depends. Now, looking at something or someone from the perspective of the practical, the social, was for them to practice moral perception. It is not the same perception and reasoning that we adopt in mathematics or physics, which deal with universals. And the racial probabilists repeatedly make this distinction between moral perception and scientific judgment. 2 + 2 is 4 was not a moral perception that could ground moral reasoning. For mathematics deals with universals or categorical truths, whereas the moral is always particular, a situated perception. Racial probabilists held a thoroughly moral perspective on race in that sense, a social perspective. Over the course of roughly 150 years, the nominal neophyte, or new convert, ballooned into a global catch-all for Catholic converts outside of Europe. In 1537, let's see if I can close this. Oops. All right. Go back to the slide. Okay. Slideshow. Escape. Here we go. All right. Okay. Sorry. Over the course of roughly 150 years, the name neophyte ballooned into a global catch-all for Catholic converts outside of Europe. In 1537, Paul III granted neophytes in the Indies, or New Worlds, a blanket dispensation to marry relatives in the third and fourth degrees of consanguinity, or blood relation. In 1585, another pope made explicit that the neophyte, or new convert, marriage benefits covered native persons in all Spanish and Portuguese settlements in the New Worlds: Indians, Asians, and Africans. In 1591, the Pope Gregory XIV expanded further the scope of new convert, or neophyte, extending marriage benefits to the, quote, mixedly engendered, whom they call mestizos. So this phrase goes in Latin until it hits the Spanish word mestizos. In 1620, Paul V renewed the neophyte marriage benefit to the same humankinds for a period of 20 years. In 1629, a pope did the same, again using the phrase, the mixedly descended or engendered, whom they call mestizos. A 1669 papal bull renewed the papal concession to African, Asian, Native American, and mixed blood neophytes to marry relatives in the third and fourth degree. And you can see this would mean that you see here the traditional chart for when Catholics can marry. They have to be 1, 2, 3, 4, and then fifth degree removed from a shared ancestor. So if a first cousin wanted to marry a first cousin, they couldn't under Catholic laws. You have to be removed in the 5 degrees. You have to be in the 5th degree, 4 degrees to remove, to marry a blood relative. Now, if we look at the marriage benefit that was granted to neophytes, this is why it mattered who was a neophyte. Because here the Pope said, well, in order to help you on your forced march or spiritual journey, what is going to happen is you are going to be allowed to marry in the 3rd degree or 4th degree of separation from that common ancestor. So in theory here and in practice, missionaries and priests could marry 2 great-grandchildren of the same grandfather or grandmother. If Europeans did that, they would be brought before the Inquisition for incest. Again, in 1690, a pope confirmed these marriage privileges for all of the groups that I just mentioned. But the problem is that in 1690, he used the Latin term mixtos instead of the Spanish term mestizos. If it seems like these folks are arguing a lot about names, they are. Now, this redoubled the very doubt that the Pope had sought to dispel. So, a period of more than 150 years of debate was not enough for Church or Crown to establish a standard definition of persons of mixed descent. What did mestizos mean? If you say these new converts include mestizos, well, what does that word mean? What does that name mean? Now, if you didn't come up with this standard definition, the marriage benefits could not be applied uniformly throughout the Spanish and Portuguese colonies. Therefore, moral theologians thought we're going to be putting these people in a position of sin, and we're committing sin by marrying them. So, priests, bishops, archbishops, missionaries, they all had to follow the opinions established by church lawyers and religious authorities that they found to be at least probable, and therefore applicable with security of conscience on a case-by-case basis. Locally, people with religious authority were making these decisions, and again, that's why they include in these manuals for priests different racial scenarios. Now, the uncertainty surrounding these mixedly descended, or mestizos, in the context of these papal marriage benefits, compelled learned men to systematically debate what we today call racial mixture and the name or nominal mestizo for the first time in history. From Madrid to Mexico City and Minas Gerais, racial probabilists argued that non-European blood was, quote, and this is a phrase from Latin, morally perceptible, only to a certain degree, whether or not it was observable, notabile in Latin, for the senses. Divergent calculations of that certain degree blended physical matter and moral matter. When is a mixture no longer a mixture? A mestizo no longer a mestizo? How long did Indian or African blood last? How many successive reproductive unions with Europeans would extinguish non-European origins? Now, this slippery slope of neophyteness for marriage benefits was tread most unsteadily by those mixed persons claiming less than 1/2 of non-European ancestry. That is the quarterones, which is usually translated as quadroons in English, with 1/4, like the Brazilian parda, who was not a parda in the eyes of her university's race court, and puchuelas, which is usually translated as octoroons, with 1/8 of non-European ancestry. In 1645, the Jesuit historian and moral theologian Antonio de Quintana Dueñas offered the most generous or capacious definition of the Pope's usage of mestizos. Citing the most renowned interpreter of colonial law, Quintana Dueñas contended that the Spanish name mestizos meant persons with African and or Native American blood, not just persons who were half Indian or half African. To answer the persistent question, are quarterones and puchuelas eligible for the papal marriage benefits, he turned to Roman Catholic canon law and Spanish law regulating incest and marriage between Europeans who were blood relatives, the medieval concept of consanguinity or kinship. And again, in the context of such unions, as I said before, consanguinity or kinship, blood relation, extends, quote, to the 4th degree, for the shared blood is drawn out and the shared blood lasts until that point. So again, until the 4th generation, Europeans would be committing incest. So they had to be 5 degrees removed in order to marry each other. That's how long, in their phrase, blood lasted, shared blood. So what Quintana Dueñas does is he transfers this to the mestizo controversy. By parity of reason, he says, thus it must be probable, that the marriage benefit for neophytes extends and shall last at least to the 3rd degree, which is that of the puchuela's blood, 1/8. Now, for Quintana Dueñas, even persons with 1/16 of non-European ancestry, these 4th generation human mixtures, were included in the name mestizos and were therefore eligible for these special marriage benefits for new converts in the colonies. So again, what he's doing is taking the chart for blood relation for European Catholic marriages and applying that to the issue of how long does does mixture or non-European ancestry last. It lasts through 4th generations, and in the 5th generation, you have become a European Christian. Quintadueñas was the first author to morally reason that these two blood situations or scenarios were equal, a probabilistic argument that would later become crucial to the legal constructs of Europeanness and non-Europeanness, whiteness and non-whiteness. The mixed person problem was approached very differently by the Spanish Jesuit and Cardinal Juan de Lugo, who was of the opinion that cuarterones, or quadroons were, quote, simply and absolutely Spaniards, end of quote. For one thing, he contended, persons with only 1/4 of non-Spanish blood should not be regarded as Indians in accordance with the legal and moral maxim, a little something should be regarded as nothing. And this maxim still exists in law, that the amount is negligible, and therefore nothing. The cardinal found further probability for his moral determination in Spanish King Philip II's late 16th century decree banning mestizos from admission to university degrees to become priests, banning admission to religious orders, because the king said that the name mestizos was applied only to persons engendered by an Indian with a Spaniard. So we have this very restrictive definition of mestizo used by the King of Spain, and the cardinal is justifying that to say, when the popes say the marriage benefits are extended only to mestizo, he means just people who are half and half. Now, this was a cultural or social or moral foundation, in that both of these strands were derived from Spanish practice, custom, traditions. That said, the cardinal's overarching argument that the name mestizo signifies only persons who are half and half mixtures, that cuarterones and puchuelas do not have the right to the papal marriage benefits, pivoted to a physical one that was common sense to persons living in a traditional agricultural society, especially in the Spanish Empire, whose horses, mules, and dogs were the envy of other Europeans. Lugo drew up 2 cases involving mixed descendants. First, the son of an Indian father and a mestiza, that is a half Indian, half Spanish woman, who was 3/4 Indian. Second, the son of a Spanish father and a mestiza, who was 3/4 Spanish, a cuarteron or quadroon. The first son, with 3/4 of Indian blood, was regarded as an Indian and enjoyed marriage privileges for new converts or neophytes. The second, however, with 3/4 of Spanish blood, was regarded as a Spaniard and therefore ineligible. So again, his idea is that you have to have half and half, at least half of non-European ancestry in order to be an Indian or an African or an Asian new convert. Folks who have less than that are no longer Indians, Asians, or Africans. They're Europeans. The moral reasoning that sustained this legal divergence for the cardinal was the same as that found in the church's teachings, I don't know if anyone here is Catholic, but on the sacrament of the Eucharist, communion, and in natural sciences doctrines on equine hybrids. First, to follow the custom of the ancient church, he says the wine used in Holy Communion was mixed with a slight amount of water, but it was regarded as wine nonetheless. It did not lose its essence of wine when it was diluted with a few drops of water. Both pure wine and the wine diluted with water were morally the same for the validity of the Eucharist. Therefore, the pure Indian who is mixed with no Spanish blood whatsoever, and the Indian in whom a small amount of Spanish blood is mixed, are not morally seen to differ. Each is simply and absolutely regarded as an Indian. The reader was supposed to take away from this argument that Indian blood endured a little something of mixture, endured a little mixture of European blood, like wine for the Eucharist endured a sprinkle of water. Second, the cardinal carried forth the standard bearer of nature's hybridity, the mule, which he defined as neither a horse nor an ass. Now, I'm struck by his legal and rhetorical acumen at this point, and this is a quote. However, if the mule can procreate, and from the mule a mare conceives, the child very much returns to the nature and species of a stallion. And he participates in the stallion's characteristic properties so much that he could almost be a horse or stallion. And he is morally regarded as a horse, end of quote. Now, by juxtaposing this natural scientific case with the other moral case of mixture, he induces the moral reasoning that the mule is a mestizo, the mare is a Spanish female, and the cuarteron or quadroon is the foal who returns to the nature of the stallion or Spaniard. So if, he concludes, so if, on the contrary, a she-ass conceives from a mule, the offspring returns to the nature and species of the ass. And he is morally regarded as an ass, although he physically differs a little something from other asses. End of quote. Here, his moral reasoning parallels that which underpins his first racial scenario. We are to understand that, morally speaking, the she-ass is an Indian, the mule is a mestizo, the three-quarters Indian is the baby mule who returns to the nature of the ass or Indian. Now, staking out the middle ground between Cardinal Lugo and Quintana Dueñas, the Bishop of Quito, Alonso de la Peña Montenegro, in 1668, argued that cuarterones, or quadroons, and puchuelas, octoroons, alike enjoyed the marriage privileges designed to help new converts in this forced march to Catholicism. In his manual from 1668, which is called Itinerary for Priests of Indian Parishes, the bishop seized upon Quintana Dueñas' argument that the church's canon on consanguinity, or blood relation, was applicable to the mixed person or mestizo debate. And this is a quote. In my probable opinion, is confirmed by what is disposed by law, that cognation, which translate out as blood relation or kin, extends to and includes the fourth degree, that's 1/16 of non-European ancestry, because blood and relatedness last up to that point. Therefore, this Indian mixture must at least, that is, this Indian mixture marriage privilege, must at least extend to puchuelas, persons with 1/8, who are in the third degree with respect to their Indian great-grandmother and have 1/8 of her blood, end of quote. This was precisely the reason, the bishop asserted, behind the custom established by the Bishop of Lima in 1638 and observed in his own Quito of granting marriage benefits to puchuelas. The bishop adduced other grave authorities as proof that the same venerable custom or practice was observed throughout the Americas and the Philippines. Unlike Quintana Dueñas, however, the Bishop of Quito's moral reasoning included an exit clause. He insisted that children conceived by puchuelas, or octoroons, with Spaniards, offspring in the fourth degree from the ancestor in Africa, Asia, or the Americas, were no longer mixed. They were Spaniards. Quote, although that 1/16th portion of Indian or African past the third degree, because that's the fourth degree, 1/16th, still constitutes something in physics and mathematics, it comes to shrink so much from the moral perspective and in the public's estimation that it is of no significance whatsoever. For in moral and legal matters, here it comes again, a little something should be regarded as nothing, as the philosopher Aristotle says, or as lawyers and judges say. Nothing and a little something should be regarded as equivalent and not be taken into consideration. End of quote. Now, as I indicated already, legal and moral analogies between blood relation in the context of European Catholic marriages and blood relation in the context of new convert marriage benefits, this idea of 4 generations washing away the non-European blood, would prove crucial to the legal and social construction of Europeanness and non-Europeanness and whiteness and non-whiteness in the context of access to jobs and higher education in the colonies. In the 18th century, from Minas Gerais and Rio Grande do Norte in Brazil to São Tomé, Angola, and Cabo Verde, legal grievances were sent to the King of Portugal's Council of Overseas Dominions regarding the occupation of posts by mamelucos, mestiços, in the broadest sense, and mulattoes. In 1726, members of the King's Council made explicit to the governor of Minas Gerais in Brazil that mulattoes or pardos within 4 degrees or generations of their full-blooded African ancestor were not to be appointed to crown posts. So African blood lasts through 4 generations, like shared blood for Europeans who want to marry each other. In Pernambuco, Brazil, during the same period, several priests with African ancestry petitioned King John V of Portugal, asking that pardos or mulattoes not be excluded from membership in the St. Peter's of the Clergy Confraternity. In 1730, the leadership of that organization reacted by revising their bylaws from 1713 to stipulate that clergy of the pardo kind, casta parda, up to and including the 4th generation, could not be admitted. There are 4 degrees, the 4-degree separation from new convert status or neophyteness had been transposed into a 4-generation separation from non-whiteness, on my view. Now, this transposition reflected probabilism's intimate relationship to law. Witness the argument presented by Portugal's royal pharmacist and the king's royal physician, Cristovão Vaz Carapinho, in a 1738 letter published in support of the life of a black saint. The physician affirmed that the 5th-generation descendant of a white woman and an Ethiopian, after successive reproductive unions between members of the mixed white line and Ethiopian, was a preto. He fixed blackening or enegrecimento by parity of reason with a chain of legal precedents that undergirded branqueamento or whitening. Quote, since when the trunk is mixed and one of the progenitors in the descent line is always white, the 5th-degree descendant comes to be legitimately white, as is constant in civil law and canon law. End of quote. Now, this physician's wording, as is constante, in civil law and canon law, relied on convinced on the legal doctrine of jurisprudence constante, the application of common law or common practice, custom, to civil and in this case is Catholic law. This translation or carrying over to what we today consider racial context of the Catholic canon on blood relation and incest and marriage had been reiterated in so many prior cases that they had become weighty precedents for legally defining in the late colonial period of Brazil who was a branco, the individual with less than 1/16 of non-European ancestry. The dispute over eligibility for papal marriage benefits in the Spanish and Portuguese colonies had been converted by the placing of many hands into a dispute over branqueamento, whitening, and whiteness. The vitality of the mixed persons problem and what it bequeathed to future generations, the Enlightenment whitening protocols as well as today's pardo problem, are discernible in Brasilia Pontificia, which is a handbook of moral theology and canon law dealing with Brazil that was published first in 1749, then again in 1758. Its author was Simão Marques, a professor of theology, philosophy, and rhetoric at the Jesuit Royal College in Rio de Janeiro, and he had also served as its rector for many years. His handbook acknowledged the Spanish moral theologians who had preceded him, Quintana Dueñas, Lugo, many others, as well as a steady stream of papal decisions from the first half of the 18th century that attempted again to produce a uniform marriage benefit for neophytes by defining once and for all how much non-European blood was required of persons who wished to claim that marriage benefit. Now, modern pontiffs, modern popes, had circumscribed these new convert marriage privileges to Asians, Black Africans, and all others who had more than 1/4 of Indian, Asian, and or Black African blood. So quadroons and octoroons were no longer eligible. They were not new converts. The eligible mixed persons were coribocas, who are today called caboclos, mulatos, mamalucos, and mestizos. So caboclos are half Indian and half Ethiopian, half African. Mulattos, you know. Mamalucos, half Indian and half European. And mestizos, which meant something different in Portuguese and Spanish, were 1/3 European and 2/3 African. But in spite of Marques's matter-of-factness, the mixedly engendered did not conform to his Enlightenment scheme. For instance, we know that the Portuguese mestizo was flexible enough to signify African and European, or African, Indian, and European admixtures in general, and that is the meaning it has in Brazil today, more like the Spanish old meaning of being open to any degree of mixture. Indeed, the conspicuous absence of pardo, which is what was used in colonial times and is entirely absent from Marques's scheme, belies its ubiquitousness in census and church documents from the Portuguese colonies beginning in the 17th century. Furthermore, pardo was used not only in place of preto, but also in place of mulatto and mestizo, especially when the individual so designated, and this is very important when we think about affirmative action, especially when the individual so designated had accumulated wealth, received a university education, performed extraordinary military service, and or served the church. Now, this semantic porousness is palpable in other kinds or categories. Perhaps most strikingly for our racial assumptions today, the original peoples in the Portuguese African settlements, as well as mulattoes born to Portuguese crypto-Jews and to Portuguese Catholics involved in the transatlantic slave trade, were often called brancos, or brancos da terra, whites from the land. So you have Africans and mulattoes being legally constituted as whites, if they were of a high rank due to commerce, agriculture, and political or religious service. Of course, Marques, if we read him, you can't find any of this in him. I should also note that Marques's puchuelo or puchuela category here was a borrowing from the Spanish racial probabilists who had preceded him, and from the papal bulls and decisions that had tried in vain to delineate which mixed persons would receive the new convert marriage benefits. It was non-existent in the Portuguese colonies of Asia, Africa, and America. So we have this Enlightenment scheme that tries to fix whiteness and fix neophyteness. Because popes in Marques's era had defined neophytes or new converts as persons with more than 1/4 of Indian or Ethiopian blood, Marques and others felt compelled to ponder at length, well, how much Indian or Ethiopian blood constituted more than 1/4? His answer was, quote, any morally perceptible portion shall be sufficient, end of quote. Certainly 1/16 of non-European ancestry was enough, he reasoned, because the religious purity statute of the Jesuits in Brazil did not admit persons with 1/16 of non-Christian ancestry. What about 1/32? Yes, that sliver of non-European lineage would propel a quadroon into the neophyte category, which was eligible for the Pope's marriage benefits. Still, Marquis drew a line in the sand at 1/32 plus 1/4 because he contended 1/64, which is not on his chart, of Indian or African blood was, quote, neither observable to the senses or morally perceptible for the intent and purpose, when neophyteness, in the consensus of learned men, must have an end, and according to church and civil laws, is at some point extinguished, end of quote. Now, up to this point, Marquis is expressly notating neophyteness, not non-whiteness. Nonetheless, the shift from neophyteness to non-whiteness, from basically religious questions to racial questions, is discernible in his manual, which serves as a window onto an emergent culture of whiteness and white privilege, which today's racial quota system, with its controversial local race boards, aspires to dismantle. The transposition of neophyteness into non-whiteness in his handbook reveals itself in the 6 scrupulous lists of mixed persons that conclude his treatment of the neophyte marriage benefits. These lists go up to 1/32 and then end. They just stop. Showing his readers that Branco begins by showing them where mixture ends. On the Jesuit canonist rendering, one ceased to be a neophyte at 1/4 of ancestry, several generations or degrees before one ceased to be a non-white. So a quadroon is no longer a new convert for the Pope or for Marquis or other racial probabilists, but that doesn't make him white. He adds these lists of mixtures after he's discussed all these story problems for new converts and says, well, at 1/32, you are still a racial mixture. You have to have 1/64, not 1/4. This is a very deep wedge. He's driving a wedge between religious status, new Christian versus European, old Christian, and what we today call race. The question was, for Enlightenment social actors, where to place the wedge. The earlier 18th century, the royal physician, the King of Portugal, had placed it in the 5th generation you were white. So if you had 1/32, you were already white. Marquis is making it even stricter. You have to have 1/64 in order to arrive at whiteness. Again, where to place this wedge between religious status and racial status. Marquis's handbook conveyed that African, Asian, and Amerindian blood mixed with each other and or with European blood was observable to the senses and morally perceptible into the 5th generation, which preserved only 1/32 of non-European founders' blood. Lists of mixed persons are placed before his reader's eyes so that, quote, and this is the priest, right, the reader, he will be able to distinguish and recognize the various kinds of neophytes. End of quote. His epistemological confidence took for granted that diverse humankinds were physical objects for our senses to grasp and for our minds to judge according to moral suititude. What we see here is a break from the previous racial probabilists who spoke in terms of non-Europeans rather than in terms of non-whites. Now, Marquis's notices to the preceding list is a section that recaps these 4 humankinds, mulatos, mamelucos, coribocas, mestiços, according to their blood quanta, before warning the reader charged with applying the Indies marriage privileges that nomenclature is slippery. Any of these 4 nominals might be used narrowly or broadly. The clergyman must diligently observe, he writes, the individuals, and not be taken or guided solely by self-declarations. With ostensibly pure-blooded Indians and Ethiopians, quote, he must investigate the parents, grandparents, and great-grandparents and deduce the sequence of generations from the founder to the potential spouse, that he may safely proceed and know with certainty which amounts of Indian or African blood the petitioner has, end of quote. Notwithstanding the existence of many other mixed persons with their names and blood quanta, if the reader, he writes, keeps the appropriate examples before his eyes, he can easily discern all of the other mixed persons that he could possibly wish to, end of quote. Now, the mixed persons problem of moral theologians and popes foreshadowed Brazil's current pardo problem, in that racial probabilism laid bare the tensions between the particularness, the situated or moral perception of race, and those aspirations to universality anchored in the phenotypical or folk concept of race. Racial probabilists argued that non-European blood had to be perceived or apprehended differently by Christian ethics or moral reasoning than it was by scientific reasoning. By the early 18th century, the four-generation calculus for neophyteness had become a four-generation calculus for non-whiteness in the Portuguese world. Although Marques drove a wedge between the two in demanding that whiteness required 5 degrees of separation from the Indian, Asian, or African ancestor. Gordy Sapatão, whom I mentioned at the beginning of my talk, the blogger, has posted that the race court's existence does not mean that Brazilians should not discuss and debate the court's criteria and its functioning. While I agree with her that the suppression of Afro-convenience is absolutely necessary for achieving the goals of racial affirmative action, I nonetheless suspect that a phenotypical criterion alone will not quell the controversy. I fear that bureaucrats and educators might be falling into the same trap as Marques in late colonial Brazil, that of reasoning about non-white race as if it were self-evident, a universal, an object in nature observable to the senses. And yet, to decide which noses, lips, skin tones, and hair textures comprise pardo-ness is to decide, not merely to observe. If racial belonging for pardos is to be judged only by what is observable to the senses of a particular race board's members, pardo-ness shall prove both infinitely variable and infinitely litigious. In short, leaving the verification of pardo-ness up to racial common sense, everyone knows a pardo when they see one, will not lead Brazil's pardo candidates, their attorneys, or local race courts out of the labyrinth of race. Thank you.